Social media is awash with unpleasant abuse, much of it anonymous. So if you're being harassed, how do you unmask the perpetrator? In this video, I'm going to reveal the legal remedy enabling you to reveal your abuser. Legal trailblazer Nicola Brookes was bombarded with offensive and malicious messages on social media by anonymous individuals. Police said nothing could be done. They were wrong. Nicola used the law to expose the identities of her abusers, and eventually one of them was convicted and sent to prison. But there were many legal obstacles along the way, which I'll explore in this video. I'm Barrister Daniel Barnett, a practicing barrister at Outer Temple Chambers in London, and I'm presenter of the Legal Hour on LBC Radio. If you haven't already done so, please subscribe to my channel for Legal Explainer videos and click the notification bell so you're alerted to new posts. Now, it was 2011, and Nicola Brookes' innocent post on Facebook in support of an X Factor contestant was to change her life forever. She became the victim of what's known as an internet pile-on, receiving hundreds of abusive messages from multiple individuals. She was ridiculed for her disability, accused of being a drug dealer, a paedophile, and a prostitute. Her home address was posted online, and her teenage daughter's face was pasted onto the body of a lap dancer. There are three main pieces of legislation designed to protect people from this kind of harm: the Malicious Communications Act, the Communications Act, similar names, different acts, and the Protection from Harassment Act. Links are in the notes below. The communications offences outlaw material that is indecent and grossly offensive, as well as threatening and menacing. The Malicious Communications Act predates the internet, but it's been amended to cover online communications. It requires defendants to intend to cause the victim distress or anxiety, while the Communications Act doesn't require that. Now, it's hard to define exactly what amounts to a grossly offensive or an indecent communication, but in the case of Connolly against DPP, Director of Public Prosecutions, these terms were described as ordinary English words. In Handyside and UK, it was established that freedom of expression includes the right to offend, shock, or disturb. So the bar for conviction is high. You or the police might also consider the Protection from Harassment Act, which makes it an offence to pursue a course of conduct which amounts to harassment when the defendant knows or ought to know that it amounts to harassment. Crucially, this offence does not cover one-off incidents, so it wouldn't cover a single post. A course of conduct has to happen, and that means on at least 2 occasions. Now, the abuse and harassment suffered by Nicola Brookes was so extreme, it was likely to have met the threshold for prosecution. But the police said no action would be taken, so Nicola was left to pursue the case herself. When people post offensive messages on social media, more often than not, they don't share their identity. That was the tactic of many of those who racially abused England's penalty takers following defeat in the European Championships. But you can use the courts to track these people down. Nicola Brookes applied for what's known as a Norwich Pharmacal order, forcing disclosure based on a principle laid down in the 1973 case of Norwich Pharmacal against Customs and Excise Commissioners. Now, in that case, the company's patent, Norwich Pharmacal's patent, was being breached, and the company was able to force Customs and Excise to reveal who was doing it. Essentially, a Norwich Pharmacal order, as it became known after the case, compels disclosure by individuals or companies that have become mixed up in wrongdoing, even if they're innocent themselves. Nicola Brookes had to prove that a wrong had been committed, that Facebook wasn't a mere witness but had facilitated that wrong, that disclosure was necessary for her to pursue a civil or criminal case, and that disclosure was in the interests of justice. Now, the harassment was regarded as so severe that the case met this test, and Facebook was required to hand over the IP addresses of several individuals, as they did in this case, but they require a court order to protect themselves from potential privacy actions. So Nicola had won the battle, and the police agreed to launch a criminal investigation, but she was yet to win the war. An arrest was made, as it turns out, of a police officer, and the case was passed to the Crown Prosecution Service. But in 2012, the CPS wrote to Nicola Brookes explaining that no action would be taken because the statutory 6-month time limit on prosecutions had elapsed for the communications offences. No action would be taken under the Computer Misuse Act, an alternative offence, because it might have been possible for someone else to have used the suspect's IP address. The case therefore didn't meet the Crown Prosecution Service's threshold of a realistic prospect of conviction. The abuse further intensified with Nicola's trolls apparently unfazed by her determination to expose them. 4 years later, the Crown Prosecution Service considered another prosecution, this time under the Protection from Harassment Act. But once again, the case was dropped because the time limit for prosecuting this offence had also elapsed. Finally, in 2018, 7 years after Nicola's innocent Facebook post, the CPS was able to take a successful case against one of her abusers, Nicky Wright from Brighton. Nicky Wright was imprisoned for harassment for 22 weeks. He was released after 6 weeks and, according to Nicola Brookes, immediately broke a restraining order by abusing her online. So a Norwich Pharmacal order is just one step on what can be a long, treacherous, winding road, but the legal landscape is changing. High-profile campaigns against online abuse, such as the recent boycott of social media by footballers, clubs and regulatory bodies, has culminated in the Online Safety Bill, which was announced in the Queen's speech in May 2021. The key proposal is the introduction of a duty of care for all social media platforms, requiring them to have clear policies protecting users from harm. They'll be obliged to act expeditiously to remove harmful content and will be required to have complaints procedures in place. The regulatory regime will be overseen by Ofcom, with potential penalties of up to £18 million for transgressors, or 10% of their global turnover. It will certainly increase accountability for tech companies, but critics are concerned because it potentially sanctions the punishment of harmful but still lawful content. The government notes that additional freedom of speech safeguards have been added since the white paper, and there's a requirement for an appeals process against the arbitrary taking down of content. Now, the law has a crucial role to play, I think, in regulating online behaviour, but given the scale of the internet, practical issues such as resources, education and cultural change may be just as important. And as this all unfolds, and it will do over the coming months and years, I'm going to record more updates and more explainer videos. If you'd like to stay up to date on this and other legal issues, make sure you subscribe and click the notification bell. And if you enjoyed this one, you might also be interested in this video about the criminal law and social media posts.